In this lesson, we're going to start looking at topic number 2 as part of our studies in the criminal justice system. This lesson specifically is going to talk about the classification of offences that exists within the criminal justice system. Now, this is something that we touched on briefly in the first lesson when we sort of took a brief overview of what this series of lessons is going to entail and the kind of things that are going to be studied within them. And one of the things that we have to think about is the structure of criminal justice in England and Wales. And this requires us to look at not only the classification of offences in general, but then to examine each of them in a lot of detail specifically. So this is essentially going to provide a useful overview for the future lessons that we're going to do, where we're essentially going to talk about summary offences, either way offences, and indictable offences in this lesson, and then we're going to spend 2 or 3 lessons on each of those individual classifications. So we're sort of going to provide something of a roadmap for the next sort of, I believe it's around 8 or 9 lessons, looking specifically at the types of offences, the indictable offences, the procedure for indictable offences, the procedure for summary offences, and the procedure for triable either way offences. And so I've sort of given the game away, really, when thinking about what the classification of offences are, because we can see that there are, in the English criminal justice system, 3 main categories for classification. You have summary offences, you have either way offences, or indictable offences. The more formal name for either way offences are offences triable either way. And this classification essentially affects how the cases are handled, which courts hear the cases, and the severity of the penalties that are imposed. And it reflects a general understanding that the quite long, arduous, difficult task of essentially going to trial and having a jury trial and having a system of criminal justice in place and that kind of nature should probably not be applied to every single offence. We should probably not, for example, have a full jury trial with lots of that takes many months and that requires the expenditure of lots of resources, where you have a very minor driving offence, for example, where you have somebody who is graffitiing on a wall, for example, versus somebody who is committing murder, which is obviously something that is required to have such arduous process of going to trial and going through that process. So that's why we have the severity sort of scale in terms of the classification of offences. Each category corresponds to the seriousness of the offence and has different legal procedures and potential penalties that can be imposed as a result of that classification and as a result of the distinction between each of these offences. Let's begin first then with summary offences. Summary offences are the least serious, if we're going to be honest, when it comes to the category of criminal liability. These cases are generally handled by the magistrates' courts, where magistrates or lay magistrates or district judges will hear a case without a jury. They don't call in a 12-person jury trial or a jury to sit for a few weeks or a few months and hear a case, because these are very small in terms of the severity of offences. They will tend to involve less serious types of criminal behaviour. Now, one of the things that's very interesting with summary offences is that it is the only offence, technically, that is exclusively dealt with by the magistrates. Okay, and essentially it means that there is no jury that is involved in determining guilt or not guilt, as the case may be. But it should be noted that all the other offences, the indictable offences and obviously the either way offences, also start their life at the magistrate's court. So where there is, for example, the basic procedures that are in an indictable offence, that will begin in the magistrate's court before going to trial in the indictable offences court, as you will, or the Crown Court, as it is actually called. Or an either way offence, of course, could be tried either way. It could be tried either through the magistrate system or as an indictable offence in the Crown Court. The penalties that are imposed by summary offences or for summary offences reflect the fact that summary offences aren't that severe, and so there is a low level of harm or danger involved in summary offences for the most part, and so there's a low level of penalty that would be imposed if somebody is found to have committed a summary offence. There are limited sentencing powers that a magistrate's court has, often an imprisonment capped at 6 months for a single offence or 12 months for 2 or more offences, and often when we think about sentencing and when we think about penalties for magistrates' offences, they will involve things like restriction to driving, for example, having your license revoked, or having a fine imposed, or community service imposed as well. That could be a criminal offence. Previously, you would have to wear an electronic tag. I don't know how popular or how widely used that system is anymore, the sort of ASBO system. But all of these sort of low-level types of penalty are often what are imposed by a magistrate's court. Imprisonment often is seen as the more serious of the summary offences, if you will. So 6 months for a single offence and 12 months for 2 or more offences. Either way offences or triable either way offences are those kinds of crimes or those kinds of offences that can be either tried in a magistrate's court or in the Crown Court, and the decision to try in one or the other will depend on a variety of different circumstances. So in terms of severity, they will often be sort of in the middle of the pack, if you will. So they're sort of the more severe end of the summary offences scale and the sort of less severe end of the indictable offences scale. Their classification will depend on a variety of factors. This includes the severity of the crime, obviously, but also includes things like the defendant's plea deal that they might have. Now, these offences are more serious than summary, but less serious than indictable, as I've just mentioned. If the defendant pleads guilty, then the case will often just be handled by a magistrate. No point wasting resources in the Crown Court when you can just deal with the procedure through the magistrate's system. If the defendant pleads not guilty, then the court may come to a decision, a conclusion, as to whether or not the case ought to be heard in either the magistrate's court or in the Crown Court. Again, this is something that is decided often by the CPS or often by the court, but sometimes even by the defendant. The defendant might even opt for an indictable plea, essentially, or for it to go to Crown Court. Under the assumption, under the guise that they might believe that they are not guilty of the offence and therefore want to have a proper trial over that particular circumstance. Obviously, that is not a decision that is available to every summary offence. Most summary offences are tried in magistrates' court, but sometimes you have these either way offences that can be tried in either. Indictable offences, as you can probably imagine, are the most serious category of crimes. They are tried in Crown Court and will often carry quite severe penalties. So long-term imprisonment, life sentences. They are often considered to pose the greatest threat to public safety and treated therefore with utmost severity. So things like, for example, murder, any kind of quite severe theft offences, any kind of sexual offences, or at least the most severe sexual offences, terrorism charges, all these different kinds of things. Now, despite the fact that they're dealt with in Crown Court, they are tried in Crown Court, they often begin their life in the Magistrates' Court. Okay, so they initially are sent to Magistrates' Court for preliminary hearings, but then will be transferred to the Crown Court for a full trial if need be. The defendant will face a trial by jury unless they plead guilty, in which case they will just the judge will dispense with the jury and pass sentence. Often the reason why a defendant would do this is because firstly you get a third off your sentence if you plead guilty straight away. This is a sort of incentive to ensure that you don't waste resources on a trial. And given the circumstances of a particular case, your counsel, your solicitor might say that it is optimal for you to plead guilty to this and get the lower sentence, because if you plead not guilty and you have to go to trial and then you're found guilty at trial, then you have to do the full sentence. You have to do the full terms of sentencing. Now, this is obviously a good system, because generally speaking, it allows for only the people who genuinely believe themselves to not be guilty, or who feel like they have a good enough case to show, to actually have the resources wasted on them to essentially go to trial. And whether or not they're found guilty or not guilty at the end of that particular situation is obviously up to the jury. So, like I said, when it comes to sentencing, the Crown Courts can impose quite severe sentencing. So this includes things like life sentences, extended sentences, and other kinds of custodial sentences as well.